In my book, Beyond Discipline, I tried to sketch an alternative educational vision of due process, and it's based largely on my experience as a disciplinarian. And I thought I would share that with you, if for no other reason, to sort of tweak your thinking about how you might move your processes in a new, more educationally focused direction if you haven't already done so. Building on the facilitator model, I became very convinced that one of the issues that we're really struggling with is so many of our systems really focus on discipline, which itself is a little bit of an outmoded concept in a lot of ways, except for the most egregious situations that occur on campus. Most of our relationships with our students are managed through educational norms, and, well, frankly, we're having contractual relations with our students. They're equals. They're bargaining with us as consumers and purchasers of a product. At least that's how the courts see it. And as a result, to discipline somebody implies a hierarchy. One disciplines a child or someone in the military, where there's very clear ordination of power and authority. But when we're working in a collaborative learning environment, really when we enforce our rules, we're essentially enforcing consumer expectations and responsible contractual relations. It's conceptually, we've moved away from the 60s, pre-60s period where we were hierarchical, where we were parents over children. We've moved into a place where even the very concept of discipline itself is up for grabs. And it occurred to me that in that word discipline is something that we often use in the academy in a very different way, as we think of disciplines as areas of learning. And I'd like to think of our interventions to manage student engagement, to manage our environment. I'd like to think of them in an educational, almost a discipline, not in the punishment sense, but in an educational sense. I noticed something when I did my work as a disciplinarian back in the days. There were a couple of people who simply don't belong on our college campuses that I ran into, people who were sociopathic and antisocial and really hadn't come to higher ed for the proper reasons. But for the most part, what I was running into was students that found themselves in trouble because they had either engaged in poor planning, had bad mentors, or had weak intentionality. And let me sort of walk through that a little bit. I saw students who cheated, who took too many classes, too many writing classes in one semester without proper pre-preparation, and they got themselves in a corner. So they started cheating, stealing from their roommates and others. A little bit of planning would go a long way. This, of course, comes up in so many different dimensions, but so often what we see is people get themselves in a pickle because they haven't thought through the implications of what they're taking on. Bad mentoring is quite common. Of course, we see this a lot in hazing cases where people have been led to do behaviors that are clearly de-mentoring, not positive mentoring in the sense that we want in higher ed. And then the ability to engage in constructive self-assessment and understand, who am I? What are my preferences? What are my aptitudes? What are my skills? Where are my allies? Where are the challenges that I will face? Getting to know yourself is a big part of being able to succeed in higher education. I found just doing Myers-Briggs to be incredibly advantageous for myself. I'm an INFP, and I went to law school. In law school, INFPs tend to be quite rare. Most are female. So I felt very isolated when I went to law school. My preferences were running substantially against the herd. And in fact, at one point, I even considered leaving law school because it didn't seem like the place for me. I found my pathway. It would have been very helpful if I had understood that the reason I was struggling had a lot to do with my preferences and the average preferences in the community that I was in. Aptitudes. How often do we see this, that people are attempting something that their aptitudes don't really predict well for and ignoring aptitudes that they have in areas where they would thrive? I worry, too, with a lot of students today that no one really gives them a chance to figure out who they are. We pressure them so much to get that first job, and parents and family, even friends, have expectations. But who I need to be as a higher learner is a choice I need to make based on constructive self-assessment. If someone supplies my idea of me to me, chances are things are going to start to go off track. I had one student that ran into some alcohol and drug issues, And I asked this individual, why are you in law school? And they said, I came to meet girls. This was a quote from someone. And I talked to this person about how he probably wasn't picking the right pathway, that law school might not be the first place to think of if that's what you want to accomplish. And we talked about why he was in school, did he really like it, and it became a constructive discussion around intentionality. I could go on and on about examples of this, but I noticed that when students go off track, when they end up becoming disciplinary issues, very often there's some place where there's an educational failure or an opportunity lost that could have prevented the disciplinary outcome in the first place. One of the clearest examples is the numbers of students who transgress our behavioral standards who have undisclosed disabilities. We find out for the first time when they get into trouble, and we're getting to the game late. We're dealing with situations when there have been violations, we're in an oppositional state, a little bit of educational energy up front, education process, could actually reduce the amount of disciplinary process that we might have to deploy. I thought it might be helpful to throw out a couple of basic ideas, things that you could chew on. If you're interested, you could pursue this a little more deeply in my book, Beyond Discipline. Master academic planning. I think it would be a really great idea for students to engage as a process designed to alleviate pressure on other processes, individual master planning. And this would include mentoring, planning, and particular emphasis on self-assessment. We could look at aptitudes, preferences, etc. Again, this isn't really the place to lay this out in excruciating detail, but a little bit of preventative work, a process up front, can take a lot of pressure off a process when there's a problem later. And I think this is probably the biggest weakness of the legalistic discipline code systems that we've had in the past, is they tend to be therapeutic and responsive as opposed to proactive, preventative, and educationally based. Compliance University is pushing us to claim our educational power, to reimagine due process and fair process in an educational way, very distinct from the kind of process that would be provided in court or in other areas, a unique process for us. Do I think we'll always have codes? Of course we will. There'll be people that transgress rules, but I would imagine in the future, if we reach a sustainable and efficient place, those codes will be largely vestigial. There will be a few instances of behavioral misdeeds, but more of our time and energy will be devoted to teaching and assessment, intervention, provention, and working with students on an individual basis. In fact, throughout Compliance 101, you're going to pick up on a major legal theme that when we do individualized assessment, we're usually heading in the right compliance dimension, and we're also most likely to be in compliance with the law. I'd also like you to think about this 4-quadrant illustration here that I put up. When you're managing a student environment, really any higher education environment, there are different ways that we can intervene. One way is through general objective standards, such as rules and codes, which is where, again, we put most of our emphasis, quadrant 1. I call it a rights and responsibilities quadrant. That's often how we talk about our codes, as denominating rights and responsibilities. We could also intervene, and we do often do this, with general subjective values, but on a generalized basis, and this would be quadrant 3, the community values quadrant. It can be very important to speak to a community on values and standards, not necessarily intervening specifically with rules and punishments, but making articulations. Think of how critical it can be when your president, for example, speaks on an issue of public importance on campus, and how really dramatic that can be in influencing conversations and behavior. Flipping to the individual dimension, I'll take you to quadrant 2. Individuals sometimes need rules just for themselves. They need objective determinants of their behavior. We see this on competition teams where I might need to go to the weight room an extra hour to get my strength up where not everyone else needs that. Or we might, on a care or threat assessment team, realize that certain rules or standards are particular to this individual or set of individuals. How about no contact orders in Title IX? This is actually a quadrant that I often consider the individual achievement quadrant. And the reason I say this is that sometimes we need objective standards applied to us so we can bring out the best in who we are. We may need to apply those rules to ourselves. Maybe an external source does. But particularizing things to individuals is a big part of what we need to do and what I think our students often are looking for. And then finally, and I actually think this quadrant might be the most important one of all, on an individual subjective level, we have to ask, what is motivating you as an individual in our higher education environment? Hence, I call this the engagement quadrant. I don't just want students who are nodding along to the general standards that seem to be the norms of the community, who are following all the rules and then do exactly what we tell them to do or ask them to do if we particularize. I want to know what's coming from the inside. Who are you? What motivates you? How do you interact with this community? And this is where we get the most important metric of all, not just attainment or graduation, but thriving. The experience that I think all students should hope for and should hopefully be given a chance to have is an opportunity not just to survive or attain, but to thrive, to find their real purpose or at least go down a pathway that leads them in that direction. The only way we're going to get to know this is if students get to know themselves better, and we get to help them do that. That's the engagement quadrant. This slide just simply pulls this information out of the grid and lines it up in a 1, 2, 3, 4, but it's essentially the same information, just a different way to visualize it. What's the point of this? Is I think we have a real opportunity to move beyond discipline, and really in two senses. One is to reduce or eliminate the idea of punishing people to the absolute minimum, cases that really deserve it the most, and looking for opportunities instead to use education process as opposed to disciplinary process. And then, I suppose if you think about it this way, when you design one centralized conceptual process for learning and development for students, it transcends any particular discipline and moves beyond a discipline to a meta-discipline. Exactly the sort of thing the student affairs professionals are particularly suited to deliver to the environment. And have you noticed that meta-learning facilities are growing on campus? Learning centers, residence life trainings, etc. This is just a natural evolution of that kind of thinking. It's time to turn to another pathway, expressive rights and responsibilities. This is the area of free speech, free association, free press, freedom of religion, etc. And I thought that we might benefit from spending a little time together to lay some basic metric foundations for learning in this area. Again, it's a very, very complex area with multiple dimensions. But in order to understand any of it, it helps to have a sense of some of the basic structure of how the Supreme Court and the U.S. Constitution builds out expressive rights and responsibilities. Again, many of us are private schools, so we're not technically under the First Amendment or state mandates for free expression per se, but our accrediting bodies often ask us to do this. We often promise things to our students through contract language that mimics or even exceeds First Amendment standards. And so again, public and private really merge on this issue in an interesting way. The legal mandates may arise slightly differently directly from the Constitution or through accreditation or promises that we've made. But we work in a business where academic freedom defines who we are, a First Amendment value, and we often promise and attempt to deliver, and often really truly do deliver, some of the most expressive and free associative environments in the American experiment. So let's talk a little bit about some basic concepts here. It really begins with an exceptional U.S. protection for content and viewpoint expression. And I want to make sure that we leave today recognizing that the Supreme Court actually distinguishes between content and viewpoint. Viewpoint being a particular type of content. This will become a little clearer as we get further into the discussion of the metric. But let's take it from the top in a broad view first, assuming that these are very similar. With limited exceptions, you can express yourself in the United States in some pretty unpopular, uncomfortable ways, really in some ways things that I find particularly vile or even unacceptable human behavior. It's nonetheless constitutional. Limited exceptions to this. So we see things like a threat, a true threat, is not protected by the U.S. Constitution, nor are fighting words or an incitement to imminent lawlessness. Pornography, particularly child pornography, occupies a special exception, a really set of exceptions to the First Amendment. Defamation is another example. But there's really no way to say this other than this, that the right to hate and the right to express hate is protected under the U.S. Constitution. And frankly, quite broadly, some of the cases are actually fairly shocking. You may be familiar with a case involving hecklers at a soldier's funeral, and the court was willing to uphold the right of people to do that. I could give you other cases that are also challenging, to say the least. The Roberts Court, Chief Justice Roberts, the current Chief Justice, has made almost a point of emphasizing the critical importance of protecting content and viewpoint. This, by the way, does not necessarily jibe with international norms. Most countries around the world are not as protective of speech as we are. And so as we have international populations dominating our institutions, we'll find that a lot of students, particularly students from foreign countries with different rules, will struggle mightily with understanding this very deep protection of content and viewpoint. The U.S. Supreme Court's also been concerned about rules regarding speech or conduct that could have a chilling effect on speech, that are overbroad, vague, or systems that lack appropriate due process in campus policy. I raised the hate speech issue, and we'll come back to this in just a second. You can prohibit speech in an unlawful way. You can also chill speech by behavior that you engage in. And in many ways, this was the gravamen of the argument around the Laura Kipnis incident at Northwestern. She published a piece in a public forum on a matter of public importance, and an academic, and then found herself investigated. She was later not found in violation of policy, but the mere fact that she was investigated raised issues in a lot of folks' minds that might chill people from engaging in certain behavior. Do you feel comfortable saying certain things? Even though you know you won't violate the policy, are you concerned that you might be investigated or criticized or even lose your job? That's the chilling effect. And the Supreme Court is very sensitive to this. They will intervene, and the federal courts clearly will do this, if they feel that there's a chilling impact that's inappropriate. An overbroad or a vague rule can also be very damaging to an environment that's trying to support free speech. And campuses, I think, particularly with hate speech codes, have really struggled with this, because there are ways to prohibit certain forms of hate speech, but you have to be very careful how you do it. And it's easy to write rules that are so broad or vague that they actually create this chilling impact or otherwise prohibit lawful speech. A lot of litigation goes back and forth in the courts trying to tune policies to get a nice match between the objective of the policy and the articulation of it and its impact on unintended consequences. Due process is critical. When we think about due process, and we talked about this a little earlier, we think about deprivations of liberty or property or even life, although we're not really in the business of incarcerating people and certainly not executing them. One of the fundamental liberties is the right to free speech. So courts, when they see deprivations of First Amendment rights at public schools in particular, will jump in the middle. And we know that there are watchdog groups out there that watch what we're doing too. Part of the issue that comes up is due process. Are people getting the appropriate process that protects their freedoms? It's all too easy to railroad people or to give unfettered discretion to decision makers, but courts have been very suspicious of unfettered discretion, because underneath that can lie secret content or viewpoint discrimination. No prior restraint. Our system is very averse to restraining speech before it occurs. It's a very rare situation where that could be allowed. We are sensitive to the heckler's veto situation, because there really is a difference between inciting violence and saying something that people become violent when they hear. And you want to chew on that for a minute, because it's not the fault of the speaker if the listeners respond violently, unless the speaker is actually inciting that or uttering fighting words or threats in some way. You may have seen the movie The Blues Brothers. neo-Nazis are demonstrating, and the Blues Brothers get so angry they drive a car right at the protesters. That's an example of the heckler's veto, and it's actually based on a real case. Neo-Nazis had actually marched in Skokie, Illinois, knowing that that was a town that had a high concentration of former concentration camp victims. They marched in a place they knew would hurt the most, I suppose, and the Supreme Court upheld the right of those folks to have a march, no content, viewpoint discrimination allowed, and who we permit for a protest or a march. Forced speech. The right to speak implies the right not to speak. And in one somewhat ironic case, the state of New Hampshire prosecuted someone for refusing to use a license plate that said "Live Free or Die." And I'm not sure they caught the irony in that. It went all the way to the Supreme Court, and the Supreme Court said that you have the right not to adopt the state's motto. If you would choose to live and maybe not be quite so free, that's really up to you. That's your choice. You can't force someone to adopt a motto. Closely related is loyalty oaths, which even recently the Supreme Court has indicated are all but dead in our legal field. Very, very few people are required to do loyalty oaths. One of the shining counterexamples, of course, is the United States president. But you have a right to be a citizen and not necessarily swear an oath to the Constitution. The right to speak and the right not to speak also implies a right to listen. And so if other speakers are drowning out a speaker that people want to hear, rights to listen are being implicated, and the court has been sensitive to that as well. I raise all of these issues to make you see how complex the balancing process is and really how particularized it can be in some contexts. The Supreme Court, again, I think is a little nervous that United States citizens are losing the values of the First Amendment, that they're not studying these rules. It may be an opportunity for us as educators to begin teaching more specifically about the First Amendment and how to use these rules. Something permeates this entire discussion. If we don't use the First Amendment, we lose it, and we may be at a point where we're on the edge of that. I know the Supreme Court sometimes appears to be concerned that we are. So I can't regulate all content and viewpoint. What can I regulate? Time, place, and manner. Time, place, and manner typically are subject to regulatory standards. So I might have a right to march, but it doesn't mean that I can march at 2 a.m. And, you know, on your campus, you may have situations where people want to bring in a very large event. You simply don't have the space for it or the security forces to make it work. It may be the sort of thing that this just isn't the time, place, or manner at all for a particular type of behavior. But you want to be very, very careful that you're not hiding content or viewpoint description, or discrimination rather, that you're not hiding content or viewpoint discrimination behind facially neutral time, place, and manner restrictions. The Supreme Court's gotten used to sniffing out people who aren't sincere, and it's important, I think, to be sincere in your efforts and very transparent. This is one of the trickier features of recent Supreme Court jurisprudence, but one that's very critical for college campuses. The court has engaged in extensive forum analysis. And what that means, basically, is that the place where speech takes place matters, and that we actually have a lot of opportunity to map our campuses and develop very specific fora with particular standards associated with them. And as we go through this in a very simple way together for the first time, you'll see the opportunities that lie here. There are traditional public fora. You can designate a public forum. Sometimes speech zones are like that. A traditional public forum is usually a place where people gather historically, or there's a designated area to do that. And this would be the area of the widest permission of content and viewpoint. Virtually no content or viewpoint restrictions are permitted at all in these places, other than the non-protected categories we talked about earlier. And so when you're marching in the street or going to the park, pretty broad opportunity to express, associate, etc. Time, place, and manner will be primarily the regulations that we're going to see in a place like that. A limited public forum is something that courts talked about quite a bit, and this is a forum that is open to discussion. What's intriguing here is, though, that you can actually limit based on content, just not viewpoint. And this is why that distinction becomes critical. It shows up in this kind of forum, and you're probably scratching your head right now. What is that all about? Let me give you an example. Let's say that you have theater on campus. That forum is open to theatrical productions. The content is specific. So I can't bring every kind of speech or activity there, but I can bring this type, a type of theatrical production. Now, let's say that someone wants to put on a production with a particular religious focus to it, perhaps even espousing certain particular religious points of view. Religion is thought of as a viewpoint, and we wouldn't be permitted to discriminate against certain viewpoints. We would allow content restrictions, but viewpoint restrictions would be axiomatically suspicious, if not unconstitutional. What does this mean is that if we go around our campus and look at our spaces and give them an articulation of the intended purpose of that space, we're going to do much better being able to manage people that want to use that space for different purposes. A lot of us, frankly, are just a little lazy with this. We just really haven't gone through our campus and tried to figure out and articulate why we have these spaces and what they hope they will do. This almost invariably leads to speakers coming in and pushing at us and saying, because you haven't articulated the use of the space and what it's for, I'm going to contest for that space and try to make it my space as opposed to yours. I'm going to jump ahead on the slide for just a minute, but keep in mind, part of the new jurisprudence of the Supreme Court is that the university is a speaker right along with other speakers. We have a right to create our space. There are also non-public fora, places that are not designed for public speech. They're speech zones, but they're not open to public constraints. And as a result, we have places where both content and viewpoint can be restricted. And for example, perhaps your president's office. And although on some campuses it is conceived of as a limited public forum, for many of us it's not. And this would be a forum where you only get to speak if you're asked to speak. You'll not be able to express certain viewpoints even though you want to do so. And the content will be driven by the people who manage that space. The president will tell you what we're going to talk about on the agenda today. It's going to be interesting, and you're going to be chewing on this. What's a classroom? And I have a feeling the answer that you're going to come up with is not all classrooms are the same. But if we don't articulate, for First Amendment purposes, what we think our classrooms are, you can imagine that students and others will try to arrogate the power to determine that to themselves. Little lesson there about use it or lose it. Finally, there are places that are non-fora where there's no speech. So the utility closet is not a place to hold a protest or even to post placards. There are places that just simply are not open to speech, and it's perfectly acceptable to have some of those on campus. We do think that you probably have to make some space for people to express themselves, and so a richly textured environment most likely has all of these fora featured in some measure. We know that there have been some examples, particularly ones that the group FIRE has challenged us on, where institutions have designated speech zones and people have been uncomfortable with the limitations on those zones. What's a speech zone? It's essentially a designated public forum in most cases. But if you don't make enough space for it, or it's in a place that people really can't access, and that's the only place to speak on issues of public importance, you're probably going to have some issues on campus, even if they're not legal issues. A piece of advice: if all you have is just one big undesignated forum, chances are the speech and behavior expressive association will begin to take on the lowest common denominator. Think of it like opening up a Wild West town, and if all you have is a saloon, you can expect that people will spit on the floor and get into fights and probably degenerate to the lower standards of behavior. Let's take a minute on rights of associations. You know, these rights were paid for dearly by students in another generation, and the Supreme Court's been very clear that students have a right to participate in associational freedom in a broad variety of ways. This often expresses itself through registered student organizations, and there's been quite a bit of litigation around registered student organizations. As we go deeper into this particular pathway of learning, we'll be going deeper into some of these issues. But suffice it to say that when we, the institution, create a registered student organization, we also have the right as a speaker to have our rights understood in balance with students. And this is why we can charge activity fees and literally make people pay into a system where speakers come that they disagree with. It's also how we won a case that allows us to permit people to say that they will take on all comers, at least at an initial entry point to registered student organizations. Obviously, this is a very complex topic, but let us say that rights of association are huge, often an issue that comes up with our Greek letter organizations fighting for their independence. This is not a dead issue from the 60s by any means. The court has also been concerned about the First Amendment's other side, which is deeply connected, is the establishment and impairment of religion. So on the one hand, we aren't allowed to establish a viewpoint and push it on people. We learned this earlier. We can't force people to a particular point of view. But we also have to be careful not to impair religion as well. And I think today in American higher education, faith-based institutions in particular are really struggling with some core issues under the First Amendment. I know in many of these institutions in particular are struggling with Title IX mandates and how those intersect with their religious beliefs expressed in their institutions. Expect the Supreme Court to take great interest in this. This feature of the First Amendment is very hallowed to the court. They've taken several cases that deal with these issues. Student activities. And again, this is interesting because often this comes under an RSO framework, Registered Student Organization framework, or there may be separate activity divisions. Again, it depends on how you organize this on campus. Student activities are very important expressive association and other types of expressive conduct. The court's shown a lot of interest in that, but they've also given us the freedom and the responsibility with respect to these types of organizations. And what I think is particularly notable here, but it's true throughout the First Amendment, all First Amendment rights imply responsibility. The responsibility to take action to use your First Amendment rights, to understand them, to respect the rights of others. People who do that work tend to do better in court. People who are a little lazy about it tend to suffer when they go to court. And so you can ask yourself right now, is your student activity system in compliance? Even with the basic Southworth case, which has been a dominant case in this field. Again, we will have more advanced training in these areas. Academic freedom and its close cousin, administrative autonomy. Our business has a unique posture in relation to just about every other business out there because we have academic freedom. The Supreme Court has recognized that although academic freedom is not specified in the Constitution per se, it's implied through the First Amendment and perhaps other features of the U.S. Constitution. We exist because of the First Amendment. We are uniquely American higher education because of it. And for this reason, and I think primarily this reason alone, we have a particular stewardship responsibility to make sure that American higher education students know their rights, understand them, and know how to use them. I think we may have assumed that people came with that understanding. I wouldn't necessarily make that assumption. When people are polled what they think the First Amendment means, they often have a very skewed vision of what the First Amendment prohibits and protects. The close cousin of academic freedom is a new doctrine that's been showing up in the courts, reference to so-called administrative autonomy. And it is worth pointing out that the Supreme Court feels that what student affairs folks do in extracurricular and transcurricular activity is equivalent to classroom instruction for First Amendment purposes. The way the court refers to our protection is administrative autonomy. And we've actually seen cases recently talk quite a bit about this associated freedom that's very similar to traditional academic freedom. The university is a speaker. This is new to me. See, when I went to law school, we didn't have the Citizens United case. And I think most of us in that era conceptualized free speech as if the institution were the vessel in which others could speak. So we were the container for the drink but not the actual drink itself. The Supreme Court's changed that. They now say that we're not just the place for other people to speak, that we have our own First Amendment mission and we have a right to it. So we join with students and others on campus as speakers. We're not just simply creating a space neutrally for people to do that. It gives us certain rights, and it showed up repeatedly in Supreme Court cases that you'll be learning more about if this area and this pathway fascinates you. Supreme Court has really emphasized that we're not just here for other people, we also have a right to have our own vision too. Multiculturalism and substantive due process intersect with the First Amendment in really fascinating ways. In another pathway discussion, we talked about fair and due process and raised the idea of substantive due process. Obergefell, the most recent case of the same-sex marriage case that many of you know about, really draws attention to the fact that due process thinking and First Amendment run hand in hand. They're very closely associated, perhaps two of the most important freedoms associated with the U.S. Constitution. So as you do more learning in this area, as you pursue deeper and more expanded understanding, keep in mind that the First Amendment never strays too terribly far from due process requirements and vice versa. They have an awfully deep connection with each other, both on a procedural and substantive level, because human freedom, which is protected by the Due Process Clause, is intimately connected to the right to speak and the right not to speak. It probably will help you when you're thinking about issues of free speech on campus to routinely go through what I call the who, what, when, and where analysis, the 4 W's. Who is speaking matters. And so we often are looking at the who's and who is coming. Is this an off-campus speaker? Is this a teacher in a classroom? Who speaks matters. Each speaker has distinct rights, and we want to assess who is speaking and who claims the rights. What are they speaking on? The whats of constitutional analysis are very significant, because if the content is defamatory, the speaker loses the right to engage in defamation. But in general, the what gives a lot of deference to viewpoint and content. Of course, it does matter where that occurs, doesn't it? So just because content and viewpoint are largely protected doesn't mean that I can go in a utility closet and conduct a protest. When? Time, place, and manner matter. We learned this earlier. So when and where things occur become critical in terms of the rights. So I think it's really good for non-lawyers and even frankly lawyers to just step back and say, who are we looking at that's speaking here? Whose First Amendment rights are on the table, thinking broadly? What is the content? When will this occur? Where will it occur? It's going to give you some good structural answers to help frame the First Amendment issues that come up. Rights imply responsibility. You know, we live in an age where everybody is a publisher. Their information can disseminate instantly and go to millions of people potentially. And that kind of responsibility was unheard of in human communication until relatively recently. Only a handful of people could do that. Now almost anyone can. Your video on your phone could be the evening news on the global news network. Things are changing. But one thing hasn't changed. The right to speak implies responsibility. Use it or lose it. Understand the consequences. And I've seen far too many examples in recent higher education news and cases of people who are using their rights, but they're not showing any respect for the rights, and they're not willing to take responsibility for the implications of what they're doing. It's critical for us to teach both rights and responsibility, not just power, but also how to use it and use it smartly. Often the best way to address speech that we don't like is with more speech. And we should embrace peaceful protest. If your first instinct is, oh no, they're protesting, how do I make that stop? You're probably coming from a place that rubs up against the First Amendment. We should want to have vibrant debate, a certain level of constructive conflict. And in fact, I get most nervous when I visit a campus and it's silent, where people aren't engaged. That's where the First Amendment goes to die. It thrives in open discourse, vibrant, diverse points of view. And again, because we are so deeply connected through academic freedom to the First Amendment, where but here should the First Amendment thrive the most? I think this is deeply embedded in a lot of jurists' minds. Courts often signal that this is the motivation. How could you, of all people, do this? Because you are higher ed. You live under the blanket of security that the First Amendment provides, and yet you're not respecting it, using it, or teaching it. It's a call to action. So resist the temptation to martyr speech. There are some people who've become awfully famous in this world by recognizing that being martyred under a rule that tries to stop their speech actually just makes them more famous. So be careful when you try to shut speech down, because it tends to grow. Respect viewpoint diversity. A theme that permeates many Supreme Court cases is if we are going to regulate something, for example, registered student organizations or student activities, in order to maintain our authority to make students learn certain things, we want to make sure that we're respecting viewpoint diversity and giving a chance for a lot of different voices to be heard, that we're not just indoctrinating, but we're actually teaching the value of the First Amendment. Hate speech, bullying, hostile environment under Title IX, and hazing are all close cousins. They tend to raise similar First Amendment issues. And so I would encourage you, as you look at your policies or work with them, and if you're revising them, don't move one of these without thinking about the implication for all the others. They're close cousins. What you do here will implicate what occurs with any of them. Use it or lose it. You've heard me say this several times. I can't emphasize this enough. I think the Supreme Court is nervous that we're losing the First Amendment, that we talk about it, we talk a good game about viewpoint diversity, but when it really comes to operationalizing it, we're actually afraid of the kind of vibrant debate that actually animates the First Amendment. I was at a meeting with one of the watchdog groups in higher education, and one of the lead people came out. I thought he was very gracious. He said, I hope someday that we won't have to engage you the way we do, that you'll sort of learn how to use the First Amendment under the law, and we'll just disappear. And I got up and I said, I hope you never go away. I think we constantly need someone challenging us to make sure that we're staying alive with the First Amendment. And of course, one of the basic things that you can do right now on your campus is begin to go map your spaces. What are these places? Because we know the Supreme Court is telling us that the First Amendment is contextual. The places that it occurs matter, and it matters that we articulate our intentionality for those spaces. Without doing that, what we'll have is amorphous combat over who owns the space and what it will become. And I think most important of all, we need to embrace a unique American meta-value that we do not have to like the speech we're hearing. We do not have to agree with it. We don't have to validate it. But we have to be willing to make space for things that we don't want to hear. And that can be really, really challenging in a world where people increasingly want to immunize themselves from the negative features of American society. We can teach the First Amendment. I think the Supreme Court would like us to do that. And again, I think one of the great meta-curricular opportunities of a generation is to sit back and teach basic civic responsibility and opportunity. I see a lot of people who are protesting and they really don't know how to do it very well. We could teach them how to be better at what they're doing, or at least give them tools to be more effective with what they're doing. Certainly violence is not the pathway. Our next pathway deals with privacy and information access. And for many of us, the first thing that comes to mind is FERPA. Back in the 70s, Congress passes FERPA, an education records management rule primarily. Why did Congress pass FERPA? Well, a couple reasons. We didn't have professional registrar services in a lot of places, and student records were not being managed in a consumer-friendly or even appropriate way. But there was also the problem of administrations dropping things in people's student records that were false, defamatory, racist, sexist, homophobic, you name it. And students couldn't even see those records, let alone correct them. You need FERPA to close the back door for civil rights laws. Without FERPA, civil rights laws that combat racism, sexism, etc., just have no teeth because the deans could drop things in your record and you wouldn't get a job. It would haunt you your whole career. You have a right to access your record, you have a right to correct it, and a right to expect professional registrar services. And sometimes we think of FERPA as the Registrar's Act because it really did help to create a very professionalized body around registrar services and management of student records. There's also, though, in FERPA that last-minute amendment that went in the statute on privacy, and that's been fascinating because for years that aspect of FERPA was used as an excuse to silo and bunker information. Can't share it. The federal government has made some exceptional effort to try to defeat that concept. New regulations after Virginia Tech really tell us that we can share information, particularly on safety matters, on a need-to-know basis, and I think that's a big takeaway from here. A sort of a basic metric of this is that if there's a business reason to share the information and there's a need to know for safety, you typically can share the information. Connected or sunshine laws and record requests, and this has become particularly burdensome in higher ed as people who are seeking accountability want to know what we're doing, and they ask for some information that we weren't usually in the habit of sharing in other generations. This varies quite a bit state to state, so it's hard to make generalizations that work across all of your campuses. This is where you need to consult counsel and deal with record request issues and sunshine laws in your particular state. And then there's medical privacy, and a lot of folks focus on HIPAA. Although interesting, a lot of the medical privacy issues, frankly, most of them aren't actually associated with HIPAA, which is mostly an electronic records management rule or set of rules. But medical privacy is important, and in fact, recently the federal government has stepped in to remind people of just how sensitive medical privacy information is. We're again going to have more particular advanced learning and training in this area. Our next pathway is criminal justice, and it's almost sad that we have to have this pathway. It's good to know that most of our populations are not headed in the criminal justice system. And in fact, I've worked in criminal justice, and one thing that was very notable to me is that in the same age group, on a college campus, you see non-recidivating populations, people who can learn from their transgressions and become better people. In criminal populations, you tend to see exactly the opposite, people who keep cycling through one violation after another and then end up accelerating to more negative outcomes. And so we've been very fortunate in our college world as we grab the people who tend not to enter the criminal justice system. But that's changing, and we see more of that. You're likely to interact with the criminal justice system in many dimensions, but one in particular is going to be search and seizure, and getting a sense of privacy, particularly in residence facilities, understanding local search and seizure law and the boundaries. There's really quite a bit to say about this, but it is important to realize that courts have recognized, for the most part, the unique texture of living in a college campus, and a lot of search and seizure techniques that might be appropriate in other contexts are sometimes not thought to be appropriate for us. You may be involved in investigations and working with criminal authorities or even testifying. We might be hiring investigators with criminal justice backgrounds. The age of investigations is upon us, and I think that's going to accelerate. Criminal investigations could also tick up a little bit because a lot of what we're dealing with now is not just a campus violation, an act of discrimination, but it's also a crime, so the criminal authorities may be involved. We're seeing, unfortunately, more white-collar crime issues come to the fore, and the Penn State incident, along with the Free Report, raised questions of the potential for white-collar crime. MOUs, we're getting pressure from the federal and even state governments to get better relationships with local law enforcement. Sometimes the way to do that was with a memoranda of understanding. As you go deeper into your training, you'll realize that there are challenges with MOUs, just getting them for one thing. But they actually raise interesting and intriguing legal and policy issues that can't be ignored. They can sometimes be hard to get. But what is most important is developing good relationships, whether memorialized or not, with local law enforcement. We have common themes and overlapping responsibilities. And so the new future college campus in compliance University is a campus that is very connected with local law enforcement and prosecutors. Title IX hasn't stopped being significant in sports. Equity issues in sports are still there. It's not as if 2011 erased that. Actually, to the contrary, there's been more enforcement. So an important feature of Title IX persists, even though the focus may have shifted to sexual violence in some ways. One of the critical things, and this is a very complex area, and it's usually special operatives that want to learn more about this, is intercollegiate athletics, NCAA, and eligibility, etc., can be very, very critical. Staying within the boundaries of that group's rules and regulations can often be a major compliance challenge and does take special training. We should remember that club sports, intramurals, and non-athletic competitions are also part of our environment, and there are definitely compliance issues that roam around that. So simply because something might be beyond the orbit of NCAA interest doesn't mean it isn't something without compliance implications. And in fact, in some ways, some of these are even more significant on our campuses. Another pathway in Compliance U will be analyzing intellectual property and cyber management issues. And probably one of the basic places to start is to start to learn differences between trademarks, patents, and copyrights. I highly recommend a book by Jacob Rooksby called The Branding of America. Jacob is a colleague and a truly promising scholar. He's written a book that really helps people who don't know necessarily a whole lot about this understand some of these basic metrics. I would really encourage you to use that resource as a way to get to know more about this. Keep in mind that many of the compliance metrics that we work with operate in the cyber world just the way they operate in the so-called real world, so that people often think there's something magic about the digital world, and yes, there are unique features of it, but a lot of the same regulation occurs. So, for example, defamation is defamation, whether it's in a newspaper or on a Facebook page. The one thing that has changed, and I think it's worth foundationally recognizing this, is that we live in a world where the ability to own information, to disseminate it, to publish it, to keep it persistent has radically changed. Digital natives of this generation are really the first human beings in human history where just about anybody can publish to very large numbers of people almost instantaneously. The material they publish could persist forever. Even now in Europe, they're discussing a right to be forgotten, which I think is something I don't know that we would have had a discussion about when I was in law school. Publish, persist, and disseminate to extraordinarily large numbers of people almost instantaneously. This ability to publish, disseminate, and persist information has been a huge human challenge through almost every generation until recently. Gosh, at one point in human history, whole swaths of human learning were lost in an afternoon when libraries were burned. Today, it's much easier to be a publisher, to get that information out and to make sure that it persists for any length of time that you want. Digital natives are approaching the world of ownership of information, copyright, trademark, and patent, and the First Amendment from a very different perspective than previous generations have. And I think it's going to take a lot of work for us to get used to this new world of the cell phone as the New York Times or the Washington Post.